Hi, everyone, and welcome to our podcast here at Kaba Law Group. My name is Elijah Doriellen, and today I have the pleasure of being joined with our founder and managing partner, Mr. Moises Kaba.
Hi, Elijah. How are you?
I'm good. How are you?
Honored to be here today with you.
Of course, me too. And so, if you guys didn't know, Mr. Kaba has been working in personal injury cases for over 38 years. It's been thousands of cases that he's worked on in personal injury, right?
That's right. And for 38 years gives you a lot of time to practice.
So, in your time practicing, can you please define for us what a personal injury case is?
So, a lot of people think personal injury just means auto accident cases, and it really doesn't. Personal injury is a wide variety of cases from slip and fall, trip and fall, premise liabilities, products liability cases, wrongful death cases, um, even cases where you have nursing home abuse. That's a personal injury case. Assault and battery cases are personal injury cases. Typical scenario: people
Right,
at a club, they get into a fight. That's a personal injury case, right?
right.
It's the assault and the battery.
Hmm.
And there's other scenarios that come about that lead to a personal injury claim. So it's a much wider body of law than people imagine.
Okay. But I know we had a conversation this morning, and it was a weird thing because I read it online. I heard a bed bug infestation or any type of bug infestation is a personal injury case for a tenant.
Well, actually, that could be two types of cases, right? It could
Mm-hmm.
be a personal injury case because the person was assaulted by the bed bugs
Mm-hmm.
as a result of the negligence of the landlord, okay, not properly, preventing that type of infestation.
Right.
But it also could be a breach of contract case.
Okay.
So if there's a lease, then if the landlord assumed the obligation to maintain the premises free and clear of rodents, mice, fleas, ticks, all that kind of stuff,
Mm-hmm.
then they breach the lease.
Okay.
And even if there's not, there might be a statutory claim and that kind of thing. So you
Right.
picked an interesting example
Okay.
because there's statutes on the books
Right.
that requires certain health guidelines to be followed when you're renting
Okay.
because you have to tender the place in a habitable condition.
Okay.
So failure to do that can also be a statutory violation. So out of that one incident, you have three different claims that you can get.
Okay. But what if it comes up unexpectedly? Like, no one ever plans for bed bugs or mice to come into your apartment. So, how would that work?
Still, then you go into the facts of the particular case because whose responsibility is it to maintain the premises? That's the
Okay.
key issue.
Okay.
Is it an issue that was caused by the landlord's lack of attention to maintenance, or is it the tenant's um, habits inside the place or the apartment or the house that led to the infestation? So that's really a particular case by case scenario
Mm-hmm.
and whose obligation it is to maintain that from happening. So
Okay. And as weird as that case is, have you ever worked on a case like that where someone has had a bug infestation?
yeah, of course, we've done all kinds of cases. We do a lot of landlord tenant litigation, and this
Okay.
is part of it. And it's not just evictions and security deposits or breach of contract cases. We handle everything related to the landlord tenant relationship, and this would be one of them.
Okay. And so the next thing, can you define for us what a contingency fee is? I know most people talk about it, they don't know. So can you clarify that for us?
Sure. It's a very easy concept once you understand it. It just means that the attorney is not going to charge you any money up front for the case, and he's only going to charge you in the event that he's successful in getting you money on your claim. So that's what most personal injury attorneys do. We certainly do it at our firm. We don't charge you any attorney's fees or costs up front. We wait until there's a recovery. If there's a recovery, then we get a percentage of the total recovery plus our costs. If there's no recovery, then you don't owe us anything, not for our time and not for the costs that we may have expended with you. So it's really no risk to you to try to pursue your personal injury claim. That's why most people should take advantage of that.
Right. I agree. I completely agree. So if you guys have any other questions, you guys can always reach out to our office, right?
Absolutely. You can call our office at 305 245 9990. That's our office number, and someone will always be there to help you out.
I hope to hear from you guys soon. And so our next question, walk me through a step-by-step process of what happens when someone who is injured calls your office.
Well, generally, when they call our office, they're complaining about pain and suffering,
Mm-hmm.
and we always tell them you got to document your medical injuries. That's key. Sometimes you have visible signs of injury, like maybe you have a scar or you have bruising, something that you can tell, and that needs to be properly documented. So you should take pictures and videos of your injuries. You should also take pictures and videos of your car and of the other person's car and of the location of the accident so we can see the accident scene. These are all things that are very important for us to be able to determine liability, which will establish whether or not you can get paid and compensated for your injuries. So documentation is key. The second thing is very important is that you must notify your insurance company within a reasonable time period, because if not, you can get into issues of the insurance company say that you prejudiced us by not telling us about the claim so that we can investigate it. And then you can get denial of coverage issues, and you don't want that. All right. And the third thing that's very important is that you need to get medical treatment as soon as possible. All right. One of the typical tactics that most defense lawyers do is they challenge the severity of your injury based on the fact that there was a delay in treatment. And they'll argue to a jury that if you were really hurt from this accident, you would have gone to a doctor right away, you would have gone to a hospital, you would have sought some type of medical care to take care of your needs, not wait 3, 4, 5 days or more before you seek that medical attention. So, in order to avoid those types of defenses, just go to the doctor as soon as possible, document your injuries as quickly as possible, document the accident scene so that we're able to determine liability, and you should be okay.
Look at you. You answered like three of my questions.
I did.